Okay. So we're here on three different motions, three different hearing or cases, I guess. Cause number DC 184771, cause number DC 1717664, and DC 201099. So you, Ms. Dorling, you filed a motion to unseal these. Kind of walk me through the law on this and kind of what your understanding is of what needs to happen now.
Okay, the motion I filed is based on Texas Civil Practice and Remedy Code 141006 and specifically under section D2C, and it states not earlier than 6 months after the date the order is issued, the court on its own initiative may, or on the motion of any person, including a member of the general public, shall unseal the unredacted order and make the order part of the public record. So I'm only seeking the final judgment granting the transfer of the structure settlement. And all of the cases that I filed on, it's been 6 months since the order was signed. So based on the code, it shall be unredacted with the motion filed.
Is there anyone else here on this? And I apologize, Tony, this should be on the record if I didn't say that. I thought I had said, I apologize. This should be on the record. Is there anyone else here? I notice there's a number of attorneys here on the Zoom call. Is there anyone here on this case? Any of these three cases? Mr. McCaskill, Ms. Raines, Mr. Godwin, Ms. Narayan, Mr. Narayan. Any of you guys here on any of those three cases I just announced?
I'm sorry, Your Honor, I didn't hear the numbers. We are here for DC 19-17340.
That's not for the unsealing of the structured settlements?
No.
All right, Mr. Narayan or Mr. McCaskill or Ms. Raines, are you guys here for this, any of those three cases?
No, Your Honor.
No, Your Honor.
Ms. Raines?
No, Your Honor.
Mr. Epstein?
Your Honor, no, I'm not here for any of those cases. I'm here for the cases that Mr. Godwin and Mr. Roberts and Mr. Narayan are on.
And I guess Mr. Roberts, you aren't either. You have to unmute. Mr. Roberts. Mr. Epstein.
Yeah, I'm sorry, Judge. We're all here for the Fisher litigation, which is next on your docket.
Okay. All right. So I'll be honest, I've never gone through this procedure. I think you're right that I have to unseal it. So what you're asking for is to just unseal the final judgment in those three cases?
That's correct.
Okay, I'll do that. So Rhonda, if you could go ahead and print out the three orders in those three cases, and then Rose, those final judgments on those three cases need to be unsealed. So Ms. Dorling, this is something that I've never done. I don't know if you have before, Rose, under the statute. I think in some cases, I don't know if in all cases, they sometimes file a redacted final order. So if it's only a redacted order, have you done this before?
Yes.
And what typically happens in terms of
some of them, the clerk would just send the orders. Others, there's cases, and if it's granted, then I'll go ahead and request the order. And if there's only a redacted order, then there's nothing for me to get. Okay.
Go ahead and redact whatever final order there is on all three of those. I'm sorry, go ahead and, sorry, not redact, I apologize. Go ahead and unseal the final order in those three cases. And if you don't mind calling Ms. Dorling whenever that's done, just so that she knows they're on, and you'll be able to get these online. And so hopefully we'll get that done by tomorrow.
Okay, thank you.
You have any questions?
No, I don't.
Okay, great. Thank you, Ms. Dorling.
Thank you. Have a great day.
Yeah, he's up there on the
I'll
screen.
need those 3 orders. I'll sign them. Once I sign them, you need
Yeah,
to
there you are. You just came up,
those
Larry.
3 cases. Just the final order.
Okay. You need me for anything?
Okay.
You'll talk to you after.
Is everyone else here? Is anyone here on any cases besides the Fisher case? Anyone here on the dismissal docket? Okay.
What is that? Oh,
So,
that's the judge doing that.
yeah, Mr. Goddard, we can hear you.
Hey, Judge, how are you, Your Honor?
Good. All right.
Well, I'm not going to say anybody's name in vain, Your Honor. I'm going to leave Larry out of it. There's Larry.
All right, Mr. Friedman, Mr. Godwin. All right, so we
Larry, you're
are,
on mute.
who's on mute?
Well, he was.
Oh, he's still on mute.
Still on mute, Larry. Larry, you need to push on.
Need to
How's
unmute.
that?
There you
There you go,
go.
Larry.
All right, sorry.
So let me ask you this. So I think I believe I set this. There's a status conference on this case. I think I probably said it. I haven't said anything for hearing. I just kind of want to figure out, there was a Court of Appeals decision, as I understand it, that just came down on this, that transfers part of the case, I guess, back to me, or however you want to, or vacates the transfer to Judge Wysocki. I'm not sure.
Just part of the case, Your Honor.
Yeah, so I just am trying to figure out kind of where do we go from here. I'm not going to make any rulings today, any final rulings, unless there's an agreement as to things. But I did kind of want to get a
All right,
feel for where we are.
it's a little complicated because there are a number of matters that were filed in the family court, and then there are a number of matters that were filed in your court. Your matters were transferred by Judge Wysocki back to her court and consolidated into the post-divorce matters. Court of Appeals basically said that matters pertaining to the enforcement of the divorce decree would remain in the family court, and new matters that were filed in your court would remain in your court. The difference of opinion between Mrs. Fisher's side, which is represented by Mr. Godwin, and the company side, which is represented by myself and Mr. Roberts, who's on the screen, and Mr. Fisher's divorce side, which is represented by Mr. Epstein, who's on the screen as well, is the difference between our opinion of what should stay in the family court and what should be transferred back to your court. Because we believe, myself, Mr. Roberts, and Mr. Epstein believes that most of the matters pertain to the enforcement of the divorce decree. And few, if any, of the matters pertain to new matters arising outside of the divorce decree. So this is going to take somebody, you, Your Honor, or maybe even a special master that you could appoint to go through each of these matters and parse them bit by bit, piece by piece, and determine which, if any, matters fall within your purview.
Okay.
Your Honor, may I, or would you prefer someone else speak?
No, I guess for me, I'd like to be able to figure out, and I'm getting some feel for Mr. Friedman. I'd obviously like to hear from the other lawyers, just how much time do we need? We need to set this for trial, I believe, and just kind of figure out where we're going from here. If we need a scheduling order, that's kind of what I want to get at. There's no reason both sides can make arguments, but I can't make a ruling at this point. This is just mostly a status conference to kind of see where do we go from here in terms of setting things.
Your Honor,
Whatever you want to say, Mr. Godwin.
I believe we are set for trial sometime in June of 2021.
On this case or the,
In the case in your court, Your Honor, and as Mr. Friedman has said, and what day is that, Carolyn?
June 29.
June 29, the case is set for trial, Your Honor. That's the first trial setting, and neither Mr. Friedman nor I requested the trial setting. I'm thinking that was just something that happens automatically down there, that when cases are filed or show up on the screen, that there's going to be a trial setting. That does not mean that we can't make the June 29 trial setting. It's just that is the first setting, and that neither of us has asked for the setting. We probably do need a scheduling order, Your Honor. My opinion is that the case probably won't be ready to go to trial until the fall of 2021. We're coming up on the end of the year here in a couple of months, and we're all still fighting the pandemic and trying to, get our arms around when things are going to open back up again. We're doing an awful lot of Zoom, which has been very good and helpful. But to do the depositions, and there are a lot of depositions going to be taken, and presumably most, if not all, but a great many of them are going to be taken by Zoom. So to do all of that, Your Honor, and have the necessary hearings with you that we'll need, I'm thinking a fall setting in the September, October timeframe. That would still be within a year of where we are now. And in most cases in Dallas, it's been my experience that if you have a case that shows up on a screen or is filed, and as yours is kind of just getting reactivated, that to get it to trial within about a year is a reasonable period. Now, that's not to say I'm locked in to that any more than I am in June or July, August, or September. It's just I know you have a large backlog of cases, no doubt, and Larry, Mr. Friedman, and I do as well, and others on the screen here. Mr. Friedman being the one that is representing the company. But so I think that we probably ought to be focused on getting a trial date that makes some sense for all of us, most notably you, Your Honor. And then from there, then we work on a scheduling order that would make sense. And I'd be happy to work with Mr. Friedman on that, to try to come up with a proposed scheduling order that we think would fit for the parties and still give everyone ample time to do what needs to be done. As Mr. Friedman said, there still needs to be some decisions made on what will be heard by Your Honor, as contrasted with what will be heard by Judge Wasaki back in the 254th. And the Court of Appeals, they spoke to that. The Court of Appeals, in its infinite wisdom, they spoke to that on August 11, 2020, when they granted the opinion, and they granted in part Ms. Fisher's plea to the jurisdiction and motion to transfer all claims that Ms. Fisher, the company, or Clifford Fisher have that do not seek enforcement of the divorce decree. And I know that in, without arguing the merits of it here, that in short, Mr. Friedman and others there, they want to take a very limited view of what was transferred. And I think that by doing so, they're misconstruing the Court of Appeals opinion, which was very clear, only matters that are dealt with in the divorce decree. The amount of money, we don't need to go through it here today unless you want to, Your Honor, but the amount of money that involves part of the enforcement action was not spoken to in the divorce decree. These standing orders, which they have themselves said are the basis for their third enforcement action, those standing orders are not a part of the divorce decree, and they're not incorporated therein. And if we need to go back to the Court of Appeals and seek further clarification, we'll certainly do so, because we believe that on August the 11th, they very clearly mandated that the case would in large part be transferred back to Your Honor's Court to 268, where it should have been, in my opinion, all along, after a lot of the pleadings started being filed like they were. And so I would respectfully suggest that we do need to sit down, and I'm happy to sit down with Mr. Friedman, or we're happy to sit down with you or with a special master, however you want to do it. And we take what I think before we go to special master route, I'd rather me and Mr. Friedman take a stab at, which we have not done, and that is of the matters that are pending. And I've got a list of them, that we try to decide which ought to go back to your court and which ought to stay before Judge Wasaki. I readily acknowledge.
I was asking Judge Hoffman to appoint me as the special master.
Well, I was thinking more of Carolyn. Carolyn Raines would be a great special master, and she could probably work in concert with your Seymour Roberts. The two of them seem to agree on so much that there's no reason, Larry, why they shouldn't be both the special master. But I would suggest.
Let me just ask this first off. Is there, and I'm not exactly sure how everybody's related to each other in terms of how all the different attorneys, who represents who and all that stuff, but.
Well, Seymour Roberts is my partner. Where are you, Seymour?
Right here.
Carolyn Raines is my partner, Your Honor. You can see Carolyn. And of course, you know, Sean McCaskill, Your Honor, he's my partner. So the three of us are on. And I see.
And Robert Epstein represents Mr. Fisher in the divorce. Robert, raise your hand.
That's correct, Your Honor. I represent Mr. Fisher in the divorce, and I currently represent him in post-divorce matters involving both the final decree of divorce and the Dallas County standing orders.
But I would suggest, Your Honor, and I'm just trying to think out loud. This is our first visit back with you. We've given you kind of a status update. Larry gave you I believe, a fairly accurate overview of where we are. Couldn't argue much with the overview of it. But I would think that we ought to at least make an effort to see if we can agree upon any of the matters that will stay with Judge Wasaki, and those are to go to you, because I readily acknowledge that the matters that truly involve the enforcement of the divorce decree would stay with the 254th. I acknowledge that. And I think those would pertain largely to the furniture and to the 500,000 Frost account. But aside from that, my position is going to be they all go back to you, and that is in the 268. And, you know, certainly the claims by the company for breach of fiduciary duty and fraud and all the misdeeds that Ms. Fisher allegedly has committed, and all the claims that we've got against the company.
Let me ask a question real quick. I'm sorry.
Yeah.
First off, Mr. Friedman, do you agree that we should move the trial setting at this point, or do you want to just keep it there for now and then have a chance to talk to all the other attorneys about whether or not to move it?
I think we should talk to all the attorneys and decide when would be a good time to schedule the case and try the case.
The question was, does Mr. Friedman think that we ought to stay on a June 29 date, or do we ought to move it over? And if he wants to leave it to June 29, I'm perfectly fine doing that. I didn't think that was where we ought to be.
Look,
I think he wants to talk about it, right?
I don't disagree with Mr. Godwin. I just think we all ought to put our heads together and come up with a realistic date that we all believe we can achieve.
I agree with that, Judge.
The other question I have, and this, you know, I haven't really thought this through, so let's say there's a situation where Judge Wasaki thinks there's a matter that belongs in her court, and then I believe there's a matter that the same matter. If I believe that the same matter belongs in my court, how do we, I guess that would be resolved by the Court of Appeals, or have y'all thought at all about that?
Well, there's two things. The Court of Appeals spoke to the fact that matters pertaining to the enforcement of the divorce decree should be in the family court. but also matters pertaining to other orders that were issued by the divorce court must also remain in that court. And maybe that's where the rubber meets the road, because we intend to enforce other orders coming out of the 254th, and we don't think that's appropriate to bring over or to transfer to the 68th if the original order came from the 254th.
Well, I of course disagree with that in part, Your Honor, for the reason that Mr. Friedman says that the orders entered by Judge Wasaki should stay in her court. Well, she also is the one that denied the plea to the jurisdiction and to transfer. And the Court of Appeals said she was wrong, that she abused her discretion. And so we believe that there are a number of orders that she entered. We've appealed on her entry of a temporary injunction that has kept my client owning 50% of the company away from the company. We've appealed on that. That's before the Dallas court. And so we feel that those are things that are going to have to be looked at there. There's nothing in that decree of divorce that gave Mr. Fisher the right to keep my client out of the company. There was nothing in that divorce decree, in my respectful and considered opinion of Judge Wasaki, there was nothing that gave her the right to enter an injunction to keep my client out of the company, because it was not provided for in the decree. And to respond directly to your question, Judge, if you are of opinion after hearing arguments at some later date that matters ought to be in your court, and that if Judge Wasaki thinks they should be in her court, then I'll seek clarification from the Dallas Court of Appeals on their August 11 order, because that'd be the appropriate way to do it. Be the appropriate way to
Okay,
do
yeah,
it.
that makes sense. I
Let me
guess
give you,
so.
let me give you two examples. So at some point, we entered into an agreed injunction with Mrs. Fisher that she would stay out of the premises of Fisher and Company. That order was signed by Judge Wasaki. To the extent that order was violated by Mrs. Fisher, it's our view that that matter should stay in Judge Wasaki's court. That's one issue. Second issue, for example, is during the course of the divorce, the Dallas County standing orders are in effect, and those orders say specifically that the parties should not, I'm paraphrasing now, should not transfer or withdraw money from specific accounts or from the parties' accounts. And there's been a record made that Ms. Fisher withdrew $5 million from one of the parties' accounts. The violation of the standing order during the divorce and the motion for contempt that was filed against Ms. Fisher for that violation should be in front of Judge Wasaki, not in front of the 68th.
Judge, first, Ms. Fisher did not withdraw $5 million from an account of the parties, that is Cliff Fisher himself. She withdrew it from the company. Mr. Fisher himself said in a pleading that she and he both had an equal right to that money. The standing orders are not mentioned in the decree of divorce. So without arguing the point, Your Honor, I'd want to argue it a lot more thoroughly in terms of this.
Yeah, guys, I think you guys are just kind of, I mean, I'm not making any decisions about anything except for scheduling matters
Right.
today. And so I'm just kind of trying to think out loud about how this is going to work. But I think you're right. If I make a decision and you don't like it and you think it should be decided by Judge Wasaki, then you can appeal me, or Judge Wasaki, same token, Judge Wasaki can make a decision and you can appeal whether or not she had the right to make it. And we'll just kind of cross that bridge when we get there. So at this point, let's just keep the trial setting where it is. If you guys want to move it, I'd be glad to move it. You're right. We are going to be so backlogged whenever we start jury trials. There's a possibility we might start very limited jury trials next month, but that's very much up in the air. And so,
How would you do that, Judge?
the proposal that's on the table is that there would be jury trials would resume. There would be they would be remote for jury selection and then live for trial. There's a lot of logistics issues that need to be worked out. I think what will probably happen is there'll be kind of a pilot trial, see how it goes, and then I'm not sure how many other cases will go after that. But it's very, very much up in the air what's going to happen. And I think they're going to start with car wreck trials and kind of move on from there. So that's the current proposal, but again, nothing's been decided.
Would that be done by agreement?
There's no requirement for agreement. No, that would be all trials, at least in the current model. Every trial, every jury selection would be remote.
No, but I'm saying, would the parties have to agree to that process?
If the current, again, I want to make it 100% clear, this has not been finally decided, but it looks like it's going to be decided. No, I don't believe they would have to consent, I guess, to this proposal. In my court, I'm going to probably require at least one side to consent, unless things, in the short run. But if we're still doing this a year from now and we still don't have a vaccine and we still have all of these issues, I think that's probably where we're going. But again, I don't want to alarm anyone too much because nothing has been finally decided. So,
Judge, if I could just add one thing. I think that this is Seymour Roberts, and I'm partner of Larry Friedman's. I think you can see by what Mr. Godwin has said and what by Mr. Friedman has said is that the lines are pretty much drawn. We have a disagreement on what's going to be before you and what's going to be before Judge Wysocki. There are about 20 different pleadings, about 11 substantive pleadings, about 8 or 9 procedural pleadings that were all filed in and around the time that your matter was in Judge Wysocki's court and before it got transferred to you. We're not going to be able, we'll sit down and talk, but I think that the lines are pretty much drawn. And I don't think we're going to be able to reach an agreement on what goes where. And so I think Larry's original thought of having a special master is going to cut to the bottom, going to cut to the quick a lot faster than having the drawn out talks with the other side, disagreeing, then having the special master. Before we can agree on a scheduling order, before we can even exchange discovery, we need to know what's in front of you. And until we know what's in front of you, I mean, that's the fork in the road. And as Yogi Berra once said, when you come to the fork in the road, you need to take it. So it seems to me that the quickest, most efficient way is to just get a special master and then have her determine it. We can argue it in front of her, and then we can move on. Because if we dilly-dally before that, it's just going to push everything back even farther.
Well, Judge, in response to Mr. Roberts, I'm not in favor, I'm not agreeable to a special master. The matter's before you, and we have scheduled already. I filed an amended motion for entry of proposed scheduling order level 3. It's set in your court, Your Honor, for October 19. That doesn't mean that that's when you'll hear it, but it's set at 2:30 on October 19. I'll be prepared to argue it at that point. Based upon what Mr. Roberts just said, is that he and his side is not going to be open-minded about what will be heard by you. And if that's the case, that'll be fine. I don't mind arguing the matter without having lawyers attempt to collaborate and cooperate and reach an agreement. But if he's telling me in advance that the chance of anything happening are very remote, or if not impossible, then no reason to waste anybody's time on it. Thank you. But so the bottom line is, Judge, we have filed a motion for a proposed scheduling order. It's set before Your Honor. Last week, Judge Wysocki, she notified the lawyers that the hearings on the enforcement that were set, Judge, for October 14 and 15, that they have been removed from the October 14 docket in her court and pushed.
Okay.
Did you hear me, Judge?
Yeah, I'm sorry. There was somebody coming in and they were talking. I got
Yeah.
distracted at the very end. What did you say?
I was saying that last week, in the last several days, Judge Wysocki did have us informed by her court coordinator that the enforcement matters that were to be heard in her court on October 14 and 15 have been removed from that hearing docket and put over to sometime after, I'm thinking after January 18 or 19, I don't have the exact day, but that's close to it. She wanted us to get together and see if we could reach an agreement on a time after that when we could have it. That came about, Judge, as a result of my asking for the Fisher side, Cliff Fisher and the company are seeking criminal contempt against my client. They're seeking confinement. And my position is, and I believe the law supports it, where you're doing that, I'm entitled to it. My client's entitled to a jury trial over peers if she's going to be put in the jailhouse in these very, very horrific times by a very irate and angry ex-husband. If he wants to put her in there where there's COVID problems.
Clearly that would be something that would be in Judge Wysocki's court though, right? I mean,
part of that would, Judge, not all of it. Not all of it. Judge Wysocki, we believe, would hear the matter involving the furniture and the 500,000, but the 5 million was not part of the divorce decree. We believe that would be heard by you.
But
No,
Your Honor,
I disagree with that.
May I finish? May I finish, Robert? May I
well,
finish?
I've been sitting here patiently waiting, but go ahead.
Well, do you call it patiently waiting when you're interrupting me when I'm talking? Is that what you call patience? I was almost through.
All right, Mr. Godwin, I think I really want to get this finished, and nothing against you. It's just nothing's getting decided today. I feel like you guys want to argue this, and I'm not making any decisions. You guys are going to set stuff in my court, and then I will make decisions as appropriate. But I feel like you want to argue, both sides want to argue this, and I'm not making a decision. If somebody wants to request the appointment of a special master, which I will say that I've probably done less than 5 times in my career, I'll consider that. I don't know that it's necessary, but if you guys want to file it, then I'll look at it. I've handled many complex cases with both of your firms and many other firms, so I don't know why I would need a special master in this case, but if there's something specific that you feel like you need one for and both sides agree, or I'm persuaded you need one, then I'll be glad to look at that. But Mr. Epstein, you have been very patient, so I'll let you speak, and then we're going to go ahead and just end this hearing because there's nothing I'm doing today.
Thank you, Your Honor. Our position, Mr. Fisher's position individually, is that the matters that were ordered by the 254th, which is the final decree of divorce, the family court standing order that was in place during the pendency of the divorce, and the agreed temporary injunction pending appeal, which the 254th had authority to do under the family code to make temporary orders pending appeal. Anything related to those orders should be heard in the 254th, which is the family court, which is the court that originated those orders. And of course, that court has the power to enforce its orders. It makes the most sense from a judicial economy standpoint and from a procedural standpoint. That is the court of proper jurisdiction. And Your Honor, I understand you're not going to make a decision on this today, but that is Cliff Fisher's position individually as relates to all this litigation that is going on, and specifically as it relates to enforcement of the various orders that Ms. Fisher has violated coming out of the 254th.
Okay, well, great, guys. That's Mr. Guy. I mean, I can let you speak again. It's just I'm not making any decisions today, so I know you guys want to argue, and I'm not trying to keep you from your chance to do that, but it's just not, today's not the day. I feel like we're fighting the battle a little before
We'd be delighted to meet and confer with Mr. Godwin. It is one of the pleasures, one of my lifetime pleasures in my career of practicing law, and I don't want to deprive myself from spending more time with Mr. Godwin.
Well, I do know this, Judge, that Larry, according to many, many sources, since meeting and conferring with me and working with me, has become a much more friendly and a much more cooperative lawyer than perhaps he used to be. I'm glad that Larry and I have had the pleasure of working with each other, because honestly, I think we both benefited.
That's no comment on any of that. So I hope you guys work everything out. You know me, you guys have worked with me many times before. I'll make rulings as they come up. So just keep me updated. We have a trial setting in place. I'm glad to move it if you guys all agree. If not, we'll have to have a hearing on it. And otherwise, I hope you guys stay safe. Be careful out there. Everybody be careful out there. And you guys have a good week. I got to get to the next hearing, which I believe is McPhail versus Milan Logistics. Is that correct? All right. Is anyone here on that case? Mr. Trimble, I think you're here on that case.
I'm here, Judge.
And Mr. Steckling, are you here on that case?
Brent, you gotta unmute yourself probably.
Mr. Steckling, are you there? Oh, he's there, but he's still
Did
connected.
you unmute yourself, brother?
Let me ask a quick question, Mr. Trimble, while
Yes,
we're
sir.
doing this. When are y'all set for trial?
I want to say it's next week, Judge. Next Tuesday, I want to say the 13th, and coming to mind right now, next Tuesday.
Let me
I
double
think
check.
so.
Let's see. Yeah, you're right. It's set for next week. So let me just kind of give you my thoughts on this. So we're not going to trial next week on your case. It's a jury trial, right?
That's correct, Your Honor.
Let me kind of give you where we are as a county and then kind of where I am as a judge in this whole process. And where the Supreme Court is the Supreme Court has said that in order to conduct live proceedings, we have to come up, each county has to come up with a jury plan. Dallas County is in the process of, or at least the civil district judges are in the process of coming up with a plan that needs to be approved by the local administrative district judge and the regional judge. There, as part of the plan that is being discussed and that may possibly be submitted, the courts would do remote jury selection and in-person trials. Obviously, since part of this is in person, that would have to be approved by the local administrative district judge and the regional judge. At this point, I'm not ordering you to trial as a remote trial. So I don't know if in the future, if I'm going to do that or not. And so I don't know if you guys, what you kind of want to do. I haven't made a decision yet.
Judge, the only way I'm going to get any kind of advancement on any resolution of this case is keep the gas pedal down. That's the only way I'm going to get any movement, get this case off center whatsoever.
Your Honor, and I apologize for being late. Brett Steckline on behalf of Milan. not true. We've entered into good faith negotiations. I understand Mr. Trimble wants to push this thing forward. He says this is a garden variety non-subscriber case, not technical. Talks about his good experiences with Zoom. I've done quite a bit on Zoom. I found it, other than 1 or 2 depositions, it's kind of been a nightmare. And while this may be simple non-subscriber negligence, it's not simple to my client, and basically their business hangs in the balance with an adverse verdict because they're solely on the hook monetarily for any judgment. So I don't see the rush. I understand why Mr. Trimble wants to push it and push it and push it and make that October 13th hang over my folks like the sword of Damocles. I understand why he wants that, but that's not fair. And I don't think that, with all due respect to the courts, we're dealing with something that, I'm tired of the unprecedented times statement. I hear it all the time, but they truly are. And it's very difficult for me to have to try this case by looking at a computer, much less folks that are at their house looking at a phone or getting distracted. I just don't see logistically at this point in time that we can pull this off and have a fair trial to these individuals on both sides of the aisle that are duty bound, we're duty bound to provide, that are entitled to this legally. So that's just my position. I mean, if we wait 60, 90 days, we'll be ready. I'm ready to go whenever the court is, but I want the assurances that we have in person and the opportunity to properly conduct cross-examination, allow the jury to see how these people react, see their physical mannerisms. I've had many cases defense side where things that the plaintiff did or did not do while they were watching testimony or in the presence of the jury had a definitive and definite impact on their ultimate decision making. So I understand why Mr. Trimble wants to push forward. I appreciate that, but it's just not fair. Thank you. And I apologize for being late. I didn't know the other hearing was over yet.
So let me just say this, that you're definitely not going to trial next week. We have in some juries, it would be impossible. It'd be impossible for me to do a trial next week. When we get to a trial setting, whenever that is, where we have a plan in place, I'm going to treat your case like every other case. So if we're doing in-person trials, or we're doing partially remote, partially in person, or we're doing a combination, whatever that Dallas County is doing, you're going to be treated just like everyone else. So you can.
That's all I can ask for, Judge.
You can.
Fair enough, Your Honor.
You can object and raise it, but understand, just Mr. Steckland, is that whatever plan gets adopted by Dallas County, we're going to have to, because if there's a live component to it under the Supreme Court order, which I think we're going to have, it has to be approved by, as I understand it, the regional judge, the local administrative district judge, and possibly the Supreme Court, though I don't think that's in the order anymore. You can object to that order, but I think it would be kind of a waste of time if the order gets adopted. So, but it's your call.
Certainly, in Your Honor, I'm sorry. In Your Honor, frankly, I had no idea how this was going to go forward. So if we have definitive protocols and guidelines that are spelled out and adopted in Dallas County, yes, and we all have to play by the rules at that point, and I'll have no problem with that.
And that has not, and I want to make 100% clear, that has not been adopted here yet. But it's the train has started moving. It just hasn't gotten to whatever its destination is, but it's on the track. So what I would suggest is I could reset you maybe to January 5th or sometime in February. This case is kind of old, but if you guys want to do a later date, that's okay too.
I'd prefer a February setting.
January 5th?
January 5th, Your Honor, just because of logistics and getting my client and witnesses involved and whatnot,
Okay.
My only issue is the January 5th works better. I have a federal month-long setting in the Northern District commencing February 3rd, I think. So, we can work around, but I think we can find something in February and live with it.
All right. So we need to pick a date, or we can pick a date, or if you'd rather, I can just call what I'm doing with all my other trials. This is totally up to y'all. We can either talk about this next Tuesday and you guys can sign up to the Zoom and you guys can talk about what dates you want to do, or we can do it right now. It doesn't matter to me either way.
I mean, I've got my calendar, Your Honor. If you want to do it now, it's fine with me. Or if you want to do it next, what was that? I think we have a
it's up
status
to y'all,
conference.
Mr. Ste. Would you rather do it next week, Mr. Ste?
It will, yeah. Next Tuesday, I don't have my calendar. I'm not in my office, so.
Okay. So
Okay,
just
no
so
worries,
it's
guys.
clear that you're not going to go to trial, but you will need to be there for a Zoom call next Tuesday at 9 o'clock with your calendar, and we'll reset this at some point next year.
And
there is a
get
chance
notice
that-
of the-
And one other thing I do want to say, there is a chance, slight chance between now and Tuesday that there will be a plan in place. I don't think that's going to happen, but so we might have additional guidance between now and Tuesday. Okay?
One further question, Your Honor. What time would that call take place? Like
9
the 9 o'clock when we? Okay,
Yes.
thank you, Your Honor.
It'll be a cattle call. So
Thank you.
we'll see you guys next Tuesday.
All right, Judge. God
You
bless.
too, Judge. Have a good
You be
weekend.
careful.
Thanks.
Valdetaro versus Wade.
Good morning, Your Honor. Nicole Figueroa for defendant Richard Wade.
Your Honor, Paul Janender for defendant William Mills.
Is Peter Harry here or anyone with his office?
I saw him on.
Pete, you're
Yeah,
on
I think
mute.
you need to unmute, sir.
Yes, can you hear me now, Judge?
I can.
Put himself back on mute.
Okay, let's go ahead and proceed, guys.
Good morning, Your Honor. Sorry, can you hear me? There's an echo. So we're here on our motion to withdraw as counsel for defendant Richard Wade. We filed this motion about 6 weeks ago. And if you remember, we had a hearing where we briefly discussed it. And as we've set out in our motion, we were retained to represent Mr. Wade in May of this year. As part of our engagement letter, Mr. Wade agreed to pay our fees for our legal services. And to date, Mr. Wade has failed to make a single payment in connection with this matter. We have discussed the outstanding invoices with Mr. Wade, and he has no plans or intention to pay our fees. At this point, we're owed over $350,000 for our representation of him in this case. We, as we've also laid out in the motion, during our representation of Mr. Wade in this case, he's been uncommunicative and has consistently refused to listen to our legal advice, which has also rendered our representation of him in this case quite difficult. And so we think that together, those difficulties with the non-payment of fees constitute sufficient grounds for the withdrawal, our withdrawal in this case.
Did you put him on notice of this hearing?
I did, Your Honor. We served him with the motion on August 24th. On September 18th, we sent him the notice of the hearing with copy of the motions. And then when we received the Zoom link for today's hearing, we emailed that to him with, again, a copy of the motion and the notice of hearing.
Okay. All right, is Mr. Wade on the Zoom call today?
I don't believe he's here, Your Honor.
Mr. Wade, if you're there, because this happened to me this morning where we had a pro se who didn't speak up. This is your time to speak up, so unmute if you're there somehow. Mr. Wade, okay. Any opposition to the withdrawal by any of the attorneys?
Your Honor, it's Paul Janender. I represent the co-defendant, William Mills. I don't have an opposition But I think it's a tricky situation because my client is has complied with things. There is, I think Mr. Harry will tell you you entered a temporary injunction after our last hearing. And I think that we're about to hear soon that there's alleged violations of that by Mr. Wade. And Mr. Mills, my client, is a party to it. There's no suggestion, nor should there be, that he's violated that injunction. But it affects the tenor of the case, obviously, if Mr. Wade is proceeding towards matters like that without counsel. That's just something I think the court needs to be aware of and balance. We did mediate this case. We thought we got very close. We think we are very close to resolving this case, but we're not there yet. And for without going beyond what I should say, some of the same reasons Ms. Figueroa just mentioned, which is they've had an issue. I've observed they've had an issue communicating with their client through no fault of their own, counsel's own. So I just say that to make the court aware of that. I'm not suggesting that should affect your ruling today or not, but I would rather you know that than not know that, Judge. Thank you.
Okay. And obviously, I'm not going to hold that against your client if there's something that Mr. Wade has done, unless they're somehow working together on it.
Well, I appreciate that, Judge, and I can assure you my client's desire is for Mr. Wade to communicate with and cooperate with his lawyers.
Okay, the court's going to grant the motion to withdraw. And I'm sorry, Mr. Harry, did you want to say something? I didn't mean to cut you off.
I'm sorry, Your Honor. I just wanted to echo what Mr. Genender said. We don't have any indication Wade is doing anything. Our counsel to serve things on and whatever.
Mr. Harry, for some reason you keep muting and unmuting yourself. I've not seen that before.
Can you hear me, Judge?
Yeah.
Okay. What our concern is that if his own counsel can't communicate with him, we're concerned about it. Just for the court's interest, the two addresses that they have, one is the address of the company in Richardson. It's our understanding that at the end of last week, the landlord locked the doors for non-payment of rent. So I don't know about reaching him there. The other one is that in the notice of the hearing that was filed by, I think, Ms. Figueroa last week on the Friday, it indicated that his address in the letter of notice was 3717 Cole Avenue. But it appears, and I just want to say this, it just appears that the certified letter, however, was sent to 2717 Cole Avenue. So I'm just concerned about us being able to get a hold of him, and we need to have some clarification that the address is in fact 3717 and not 2717.
So to the extent, Mr. Harry, there's a typo in one of the addresses, I can look at that and make sure that you have the correct address.
Ms. Figueroa, I'm going to order you to produce any information you have on how to contact your client. So
absolutely,
all emails you've used, all addresses, business, personal, any social media, if you've been Facebook messaging or DMing him, or is that what it's called, DMing?
I don't know.
On Instagram, is Instagram DM? Is that what it's
Judge,
called?
Judge, I got to tell you, that's a pretty impressive list of acronyms you just did. I'm impressed.
I'm impressed with myself.
I've exhausted my social media knowledge.
Snapchat or whatever. What's it called when you Snapchat somebody?
Snapping them.
Snapchat them. Whatever way you've been communicating with them, I want you to provide that to the other attorneys, because I am as concerned. Let me just say one thing, and this has nothing to do with the withdrawal, but I do want you guys to think about this, is it sounds like that you guys are gearing up for a contempt against Mr. Wade. Is that correct?
Yes, Your Honor. We should be, in fact, we should be filing that today. I contacted counsel at the end of last week as to whether or not they would oppose it. I haven't heard anything, but I'm assuming, and maybe they could say now for the record, that they don't oppose the motion for sanctions, but we believe he's been violating the court's, the agreed injunction that everybody entered into multiple occasions.
So one thing I want you to be thinking about, it's something that I've been thinking about a good bit, is that virtually every hearing I've had since the pandemic started has been virtual, remote, mostly on Zoom. But if there is a hearing where you want to put someone in jail, if that's one of the remedies you're asking for, which is okay, that's if he's violated an injunction, that's one of the remedies, then that would need to be in person. I'm scheduling all of those on Fridays, not on Mondays. So just be aware of that and make sure that you contact my court coordinator and say, hey, look, Judge Hoffman has said that I have to set this on a Friday and I have to do it in person. And we need to kind of figure out, if there's going to be a lot of people here, kind of how we would do that. But I just need to know so that we can have a bailiff and, our courtroom set up for it and things like that. So just be kind of aware of that if you do decide to move forward with a request to put him in jail.
Yes, Your Honor.
Okay. Anything else we need to chat about, guys?
That's it, Your Honor.
Good week, Judge. Thank you.
You guys be safe, and I've signed the order.
Thank you.
Bye-bye.
Okay. So, Mr. Tobolowsky, Ms. Compton, we've had a number of hearings. Remind me again, I don't think it's set for today, or at least not on my docket. What were we doing today?
Today, Your Honor, we have the plaintiff's motion for summary judgment, which and the remaining portion of the defendant's partial summary judgment motion that was continued to today to be heard along with the plaintiffs because it's on the same issue. I can tell you one of the points of confusion may be this was originally set at the end of September, I believe. And my recollection is we got a call from, I think, your coordinator asking if we would bump it. I don't know if there was something with your calendar or otherwise, and it got bumped to today.
Okay. Is that correct, Ms. Compton?
It is. And we had asked the court in our notice of hearing was since the two issues were continued on the tenant in common issue, you ruled against us. And then there was the two more issues. One, that the plaintiffs are not partners. And then secondly, fiduciary duty. And so if you would like for me to start with those, I can do that. And then we have the plaintiffs tenant in common issue and their summary judgment, all that. It's up to you. I'm happy to start if the court would like me to.
Your Honor, I've got the one other issue that I forgot to mention was there's a motion, a plaintiff's motion to strike an expert designated by the defendants. And I'm not trying to argue with Ms. Compton. If the hope was that issue becomes moot if the court rules on the portion of the summary judgment that has already been partially heard, which is the tenant in common issue. And I just wanted to address that at the outset because otherwise it may make sense to do that first.
I'm not exactly sure I understand what you were saying, but
the motion to strike the expert is Roland Love. He is solely testifying regarding the tenant in common property dispute. And that was the main issue that was argued at the hearing on the defendant's motion for summary judgment. And so it sounds like handling that matter first could moot the second portion of today's hearing, which is on the plaintiff's motion to strike. And again, I just think today being finally the hearing where it's plaintiff's motion, we should have the opportunity to at least lay the groundwork and not have to correct a bunch of misstatements that get laid for.
So let me just ask this. There's a number of other people here on the call. There's a Sophia, a Yolanda White, a Robin B. I know the times are involved in your case. Are those folks all with you or someone else?
Robin, Yolanda White is my paralegal. So, and Your Honor, as far as the order, obviously it's.
So who's Sophia and Robin B?
Hi, morning, Your Honor. We had a scheduling conference scheduled for 10 this morning, but
Okay.
I believe we were taken off your docket. I was actually just sending you a message just to confirm that it was off your docket before I logged off.
Yeah, I don't see it on my docket. Let me just double check.
It was the Canon versus AAA.
I don't see it. Do you have a cost number?
I do. It's 20-09637.
Just a second. DC 20 what?
09637.
It's set right now for November 2nd. Is that, but there's a proposed order that was just submitted. Let's see. You're moving it about a year, it looks like. Yeah, that's fine. We'll go ahead and reset it. Yeah, so you got us an order. We have it. So go ahead. Your hearing would be off. So,
okay.
All right. And this was an agreed order, correct?
Correct.
We'll print that out right now. Okay. And thank you, ma'am. And
Thank you,
Your Honor, Robin B is actually Robin Time Beckerman. Her, Brenda Time, and Ralph Time are all the plaintiffs in this matter.
Sounds good.
And Your Honor, totally up to you. Of course, I defer to you. The notice of hearing stated that the remaining continued issues would precede the rest of the issues. So it's obviously your call, and I defer to you.
Let's go ahead and resolve the tenant in common is the one remaining issue from the previous hearing, correct? No, I'm sorry, it's the remind me what's carried over from the last hearing.
So
you ruled.
Both the plaintiffs.
You ruled against Richmond Trust and the defendants on the tenant in common issue. So
Okay.
that now remains to be heard as far as the plaintiffs on that. But what you continued and what we were, arguing was the two remaining defendants issues, which was that the plaintiffs are not partners in Richmond Trust. And then secondly, that there's no fiduciary duty to the heirs. So that's the one that was continued.
And the plaintiffs have moved for summary judgment on the same 2 points.
Correct.
Okay, let's go ahead and continue. Let's go forward with the matters that were previously continued.
Thank you, Your Honor. I would like to start with the fact that plaintiffs are not partners, and we're going to whip through this, Your Honor. I know that's how you like it. So there's 3 reasons why the plaintiffs claim that they are partners. Number 1 was that assignment document executed 16 months after Judy's death. Number 2, receipt by the heirs of K-1s and franchise tax documents from the CPA. And number 3, a new unpled oral consent by Mark and Harvey to admit the heirs in 2008. And so quickly, what I was going to say is the Texas Business Organizations Code is clear, and a state cannot consent to make the heirs partners. The 2008 trust cannot consent to make the heirs partners. The Richmond Trust Partnership cannot consent to make the heirs partners. The CPA cannot consent to make the heirs partners. Even if Judy was alive, she could not make the heirs partners without the consent of Mark and Harvey. The code only says the partners can make other partners partnership. So, and then quickly, as far as the new unpled oral agreement, it doesn't make sense because they brought suit saying Richmond Trust would not let them be partners. And now they were saying there's some oral agreement in 2008. There's been 6 depositions taken, thousands of pages of documents produced. Not a one of them says there was an oral agreement. And not one of them, they say they're creditors. And then they also say neither Mark nor Harvey would agree that they are partners. They also said that they had 2 lawyers before they hired Mr. Tobolowsky. So between 2008 and 2018, they had 2 lawyers, and they had an opinion that they were creditors. So I will just quickly whip through the evidence that I would like to show the court. And just as a recap, Judy died 2008. No dispute, there was no partnership agreement.
I've already heard all this. Let me hear
Yeah.
from Mr. Kowalski.
May I show the evidence, Your Honor? Just quickly? Just quickly.
Okay.
Okay, let's look at, this is Brenda Time 869. Your Honor, this is 3 years after the assignment was executed. And this is Ralph telling Robin and Brenda, when Robin and I met with Mark and Harvey, I briefly communicated our findings with regard to being creditors to the partnership, and essentially that we were owed mom's interest. Mark disagreed and said the law meant we were simply due the proceeds from the partnership business, but we're not partners. And then if you look down on the page, this is critical. Ralph says, as a proposal to his siblings, begin the process under the Texas Business Organizations Code and send Mark and Harvey a written demand for the redemption of mom's partnership interest, which would detail all requirements outlined in the memorandum from Clint. And Clint was their attorney. And then Brenda Time 798. This is Exhibit J. This is from Robin. She signs at the bottom, love Robin. And then she's saying to Uncle Mark and Uncle Harvey, we understand you did not intend to enter into investments with mom's heirs, and knowing this, your willingness to discuss the situation has not passed unnoticed 3 years after the assignment, Your Honor. And then quickly on, this is Exhibit F, page 113 of Ralph's deposition. I say, would you agree with me that as of November 6, 2013, you knew that it was Mark's position that you were not partners in Richmond Trust? He says that I knew that was Mark's position. Yes, that is fair to say. I would just simply, excuse me, yeah, I mean, we received an opinion from Clint that we might be creditors. Then Exhibit K, and this is just offered not for the substance of what the offer was, but to show that they were told they were creditors. Here, Clint David said he sends a proposal to redeem the heirs' creditors' interest. Clearly, they're not thinking they're partners. Then this is Exhibit S from the plaintiff's exhibit. This is that assignment document. Let's go to the assignment document, Exhibit S. Do you have it? Anyway, if you can find the assignment document, Yolanda, it's Exhibit S to the plaintiff's documents. In the exhibit, the assignment document on page 1 says that Ralph is the executor of the estate, and he's the assignor, and Ralph is the 2008 trustee. There we go. And you can see, Your Honor, it's dated January 6, 2010. So there's no way that the estate, the executor, can be assigning anything that has to do with the partnership to accept them as heirs. Same thing with the 2008 trust. And then Ralph, just staying up there, Yolanda, you can see that the heirs include Ralph and then the other heirs, which are the plaintiffs. And if we can quickly jump to the very, very last page, you will see that it says notice received and transfer accepted Richmond Trust investments. And so, Your Honor, nowhere on this document does Mark accept the heirs as partners, and nowhere does Harvey accept the heirs as partners. And Richmond Trust doesn't have the right to accept the heirs as partners. And then in addition, the assignment document was attached as an exhibit. And I know it's superfluous in terms of your thoughts on admitting exhibits, but this exhibit was attempted to be authenticated by Ralph in a declaration. However, there's conflicting evidence, so it's inappropriate to admit and consider this document. And then also, I have specific case law in my objections to evidence that states that they did not attach the assignment to Ralph's declaration. Therefore, it's not a valid authentication. And then quickly, Brenda Time 805, this is Exhibit J. You heard the plaintiff say it's preposterous that somebody would do this assignment document just to change the payment stream. But if you look at what Ralph said, in 3 years later, I'm pretty sure this only formalizes the distribution of mom's interest in the partnerships and doesn't have any bearing on creating a partnership. And then just the final issue, Your Honor, it's this new, there was an oral agreement, and it's actually, this is like created by the lawyer in this case. Page 152 of the response says, the reason why the assignment was backdated, intentionally backdated and made effective prior to its execution, was because that's when that oral agreement was created. However, in Ralph's deposition on page 63, he says, I said, and why was this document dated January 6, 2010, but effective August 1, 2009, if you know? And he says, yeah, my answer would be, I would ask my attorney. That's who did this for me. So no clue, never was there any discussion of any kind of oral agreement. And then on page 94, I can just read to the court very quickly. I said, I was trying to find out every basis for them saying they're a partner. And he says, the assignment document, I think, is an important piece of information to assigning my mother's heirs their percentage in the partnership. Yeah, I think that being treated by my uncles with many respects to the partnership and joining in and receiving draws and property maintenance discussions and filing taxes, I think all those things support that position. Yeah, that's what I think. And as the court knows, you know, the partners must actually consent, not anybody else, to becoming a partner. And then finally, and so we do ask that the declaration of Ralph be stricken as a sham declaration. And then our final point is their second theory is that they got K-1s and franchise tax documents. And so if we can go to Exhibit L, this is my last exhibit on this point. This is the affidavit of Catherine Quinn. And Your Honor, the plaintiffs complained, oh, she said this is on her best of professional knowledge and belief. But if you look up 2 paragraphs, she says it is stated within her best personal knowledge. She says up above, this is are true and within my personal knowledge and true and correct. And she says at paragraph 8, Mark told me on a regular basis that since Judith died, the heirs of Judith were not partners but creditors, because I needed to track the heirs' creditors' interest until a redemption price was paid, because Richmond Trust continued to pay 1/3 of the profits, which under the code does not make you a partner. They were paying it to reduce down what they were ultimately going to owe, because they knew they were going to owe a redemption payment. And then she says, paragraph 11, Richmond Trust was making regular redemption payments. I sent them K-1s because there was no agreed redemption price, so it was not possible to determine what part of the redemption payments were principal and what part were interest. And she was surprised to learn that the heirs sued Richmond Trust, claiming they were partners, as Mark continued each year to question the tax reporting mechanism. And once a valuation in 2018, when there was no agreement that could be reached, Mark and Harvey got a valuation. And once that value was determined, they could then turn it into a 1099 that had a debt with an interest amount, et cetera. So, I mean, and then 2, whatever the CPA did, that cannot make them partners. As far as the fiduciary duty issue, which is the second issue that remained and continued, Your Honor, Mark took over managing the partnership in 1985. Clearly, limitations have run on any kind of claim of breach of fiduciary duty, to the extent they are found to be
but you're going into new arguments, right? That was not continued.
Oh, this was the second of the 2 continued arguments.
Okay.
It's the breach of fiduciary duty claim, and it's very, very short. So basically, they're claiming that Mark and Harvey breached their fiduciary duty. And so number 1, limitations have run. Number 2, if they're found not to be partners, there's no breach of fiduciary duty. There's no fiduciary duty. And number 3, if they're tenants, if they're not found to be tenants in common, there is no fiduciary duty. Also, and then there's just 3 little pieces of evidence. One is in asking Ralph I said, did Mark manage the property since 1985? This is on page 171. He said, that sounds correct. And I said, and in fact, you've complimented him for all the work over the time managing the properties, right? Yes, I have complimented him and thanked him for all the work he did on our behalf. And then on page 180, I say, tell me all the basis that you say that Mark breached his fiduciary duty. Not one thing. He said, I refer you to my interrogatories. And so it sounded like the attorney prepared the interrogatories. He could not think of one reason, asked again and again, how Mark breached his fiduciary duty. And finally, when we were in Robin's deposition and I was asking Robin, why are you suing Harvey for breach of fiduciary duty? She started crying. Mr. Tobolowsky got on the record, and we've got that testimony if you want to see it. And he says, now that we are back on the record, plaintiffs are non-suiting the breach of fiduciary duty claim against Harvey Richmond only, and the necessary paperwork will be filled out. So that's the end of my argument. I would ask that you find that the heirs are not partners in Richmond Trust and that there is no fiduciary duty owed. There's the business judgment rule. There's been no testimony that in any way there has been a breach of fiduciary duty, and that would narrow the scope of the arguments for trial, or the issues for trial. Thank you, Your Honor.
Thank you, Your Honor. In response, I will try to only address the main issues, the most material and relevant issues for today. And I'm going to, unless the court wants me to, skip over the tenant in common issue, because I think that that's already been argued and the court's made its decision there. But on the partnership issue, the one big thing I need to clarify, because Ms. Compton misstated it multiple times, is the defendant or the plaintiff's position on that issue. The plaintiffs are claiming they are partners. There are two reasons why. None of those reasons are the evidence themselves. The reasons are that the defendants consented, and the evidence proves the fact that the defendants consented. For example, the plaintiffs are not arguing that the K1s make them partners. That would be absurd. They are arguing that the K1s prove the defendants already consented that they could become partners. Otherwise, they would have never received K1s. So with that clarification in mind, and reminding the court that the consent under TBOC 152.201 does not have to be in writing. It just needs to be provided. So the argument that there's not a writing or not a writing signed by both of the partners is irrelevant. Both of the partners consented, and both of them testified at their deposition that whenever a material decision needed to be made, the partners would discuss, they would decide on the action, and then the managing general partner, Mark Richmond, would execute, which is exactly what happened with the assignment agreement.
Can you share screen? You said you quoted the TBOC. Can you share screen that provision?
I can pull it up really quickly. I don't know that I have it up.
Are you talking about 152.201?
The one he just quoted.
Yes.
You have it, Catherine?
I have it. I could show it the dinosaur way.
No. I want to share screen it.
It says a person may become a partner only with the consent of all partners.
And where does it say that you can do that? Does it have to be in writing, or can it be just a nonverbal consent, or an oral consent, I guess?
The plain language of the statute does not specify. It just says the consent must come from the partners. And I've got this pulled up, Your Honor. It's just from the internet, but.
Okay. That's all it says.
That's all it says. That wish.
All right, so let me just kind of short circuit this. I'm going to go ahead and grant the summary judgment that they are not partners. Let's deal with fiduciary duty.
Your Honor, I'm sorry, you're granting the defendant's motion on that issue? Is that what you said?
That they are not, I'm granting the motion they are not partners.
Okay. On the fiduciary duty issue, Your Honor, the main issue there, or the main response there, would be the defendant's argument was based on the fact that the plaintiffs were neither partners nor co-owners of the properties in dispute. And the court hasn't ruled on the plaintiff's motion for summary judgment on the property dispute, only denied the defendant's motion on that issue. If the court grants the plaintiff's motion on that issue, the defendant's argument that there's no fiduciary duty because there's no co-owned property is moot and irrelevant. And the motion for summary judgment would have to be denied on that grounds alone. And with regard to the statute of limitations issue, there's not an allegation that the only breaches of fiduciary duty were back in 2008 or 2009.
Well, you're jumping ahead here. So I've ruled they're not partners. So what would be the basis for them having a fiduciary duty to your clients?
That the plaintiffs are co-owners with the defendants with the 3 properties in dispute.
Okay, and that leads to a claim for fiduciary duty.
Correct, because the defendant has been managing the.
And one of the defendants has been non-suited, correct?
On the breach of fiduciary duty claim, yes, Your Honor. Harvey Richmond has. He's not the managing partner. Mark Richmond is the managing partner. And Mark Richmond is the managing brother who was operating the co-owned properties as well.
Your Honor, I don't believe that. I mean, maybe that was your intention, Mr. Tobolowsky, but the amended petition, I did not see that it still refers to Harvey.
Okay, I've just agreed on the record that Harvey's
okay.
Okay. Ms. Compton, for protection of your client and just to make it clear, you might want to get us an order on that non-suit, or Mr. Tobolowsky. Somebody needs to give me an order on that non-suit.
I'm happy to do that, Your Honor.
I didn't hear what you said. Did you say you would do it? Okay.
Sure, I'll do it, Captain.
So what is your argument on what did the managing partner do to breach the fiduciary duty?
There's a couple things that the managing partner has done, and one of them is renting portions of the properties to family members for below rent or below market rent. The other has been foregoing on even considering offers of sale simply because he did not want to sell his 1/3 undivided interest, and a host of other things along those same lines.
Okay.
There's been money paid to him over the years as well.
The motion for summary judgment on the fiduciary duty is denied. What else do we still have to rule on?
On plaintiff's motion for summary judgment on the tenant in common issue, that they are co-owners of the properties in question. The one that Your Honor denied the defendant's motion on.
All right, so I'm pretty sure I know how I'm going to rule on that. Ms. Compton, why don't you make a quick argument on that?
I'm happy to do so, Your Honor. I'm ready. Okay, so there are basically a handful of reasons why.
And there's no reason for you to argue anything you've already argued before, or to try to make me change any rulings I've already made. So just limit it to what's
okay.
left.
Well, all right. So what I would, I'm sure you will stop me. But number one, we didn't really discuss the judicial estoppel that in Exhibit I. 2 times Ralph Time has gone before the estate probate of Judy and shown schedules. Yolanda, if you could pull up Exhibit I.
Your Honor, this was discussed at the last hearing.
I don't, but go ahead. I'm not trying to interrupt you, Michael.
Your Honor, unless you don't want to hear from me, it just seems like the plaintiff's entire motion for summary judgment has kind of been hijacked by the defendants.
No, I'm not trying to do that. So if I can just show
Ms.
you.
Compton, I would highly urge you to get to your best points on this because I'm about to grant the motion in Mr. Tobolowski's favor, and this does seem to be kind of repetitive to what we discussed.
Okay, then we'll remove that exhibit. So Your Honor, under, this is if I can show you, I don't know if you've read the case law or if you'd like for me to show you, but the bottom line is, and what I would urge the court to deny their summary judgment on tenant in common is because what they're saying is you can only look at the four corners of the deed, and the deed says what the deed says, and you cannot bring in parole evidence. But I have specific case law that says equitable title is a different animal. If you equitable title means you get, the two cases I have, may I bring up a case for you, Your Honor?
Sure.
And if I can actually do it, let me see. Can you see it, or I need to share it?
You need to share it.
I will learn how to do this and be very good at it one day. Okay, do you see it?
I don't.
Share. All right.
Still, there we go.
Okay, so Your Honor, there's two cases on this that clearly make it. So in this particular case, that it's one partner against two other partners that are dissolving, and one is saying it's a partnership, the other saying they're not. And the court is explaining, while a constructive trust is designed to prevent unjust enrichment, the doctrine of resulting trust is based upon the concept of equitable title should rest with the party who furnished consideration for the purchase. Let me just go down to the important part. The court says, I find it. Moreover, the facts giving rise to a constructive trust or a resulting trust, which is equitable title, may ordinarily be shown by parole evidence, parole testimony, including the identity of the property purchased and the source of funds. And in this case, the court says, because the theory of constructive trust or resulting trust is an exception to the statute of frauds and parole evidence is admissible, the trial court erred in concluding as a matter of law, the instrument of conveyance established that the land was owned by the individuals. So that's one case. Then there's one more that was actually cited by Mr. Tobolowski. And let me find it. And that's the Jewel case. Oh, I got to first share. Patience, please. Okay. So Jewel. If you can see that, Your Honor.
Can't.
You can't, I haven't shared it yet. Thank you for being patient with the dinosaur.
All right.
Is this the Jewel case? Yes. So in the Jewel case, the court says again, and this is the critical part as to why the tenant and they are not tenants in common. All the cases they cite to are looking at the four corners of the deed, and the deed is the deed, and that's all you can look at. And so so what this is saying, Your Honor, is real property can't be conveyed even between partners orally. So I can't say I'm conveying this to you, that you have to do it in writing. One may, however, acquire an equitable interest in real estate without formal conveyance, which interest can be enforced by a court of equity as circumstances may justify. If real property is purchased or paid for by partnership funds, but record title is in one of the partners only, a court of equity may, in a proper case, impress it with a constructing or resulting trust, which is equitable title, in favor of the partnership under the doctrine of equitable conversion. And Your Honor, a lot of the cases that we cited, I mean, this is really outside of all this parole evidence that the plaintiff has talked about. So they refer to the Stewman case, the Luckel case. All these cases are dealing with someone trying to interpret what's inside the deed or construe the deed. We're not trying to construe the deed. We're saying these are partnership properties, and the courts, if you look at a number of the cases that I've cited. So Faust versus Old American, King versus Evan, although legal title was in appellant's name, equitable title remained in the partnership. And they said it said it is incorrect that the only way land could be partnership asset is for it to have been purchased with personal property. And then you look at the intent of the parties, and that's what, I mean, obviously plaintiffs spent pages and pages talking about you know, the intent of the parties, and well, maybe it was that maybe the partnership didn't exist. I mean, there's a reason for that. It's because he wasn't addressing equitable title because it's not in his favor. And if you can look at Exhibit F, one thing, Your Honor, Exhibit F was testimony of Ralph. And basically I went through every indicia of ownership.
Your Honor,
say,
this was repeated 3 times at the first hearing, and all of the indicia of ownership that Ms. Compton is about to go through are misstatements from the record.
Your Honor, I totally, I've got the actual words. If we can.
All right, Ms. Compton, let me hear from Mr. Tobolowsky at this point.
Your Honor, she's misstated the law on the issue. That's the fact of the matter. The fact of the matter is, in order for the defendants to even have a chance to even consider parole evidence, they need to have evidence of how the property was purchased. They have none. They've admitted they have none. Those admissions are attached as summary judgment evidence to our motion. Even then, if they did have some evidence that the partnership was formed prior to the purchases of the properties and the partnership's funds were used to purchase those properties, then we can get into an analysis perhaps about what presumption applies. But Texas law is exceedingly clear that you cannot use parole evidence to construe the intent of the parties to a deed. And that is what Ms. Compton is trying to do. The intent of the parties is what would tell us whether it's a partnership property or whether it's not. And I think Ms. Compton did a good job of showing the court only the portion of those cases that are relevant because, Your Honor, those are distinguished in the plaintiff's motion for summary judgment as well. Again, Your Honor, I thought that this issue had been thoroughly briefed.
Mr. Tobolowsky, let me just say this. Just because I denied her motion doesn't mean I would grant your motion. If there's a fact issue on this, which is what I kind of feel like there's a fact issue here, then I would deny both motions. So,
Your Honor, sorry. So
I'm struggling to see why there wouldn't be at least a fact issue on whether or not there should be is it equitable trust? Is that what it's called? An equitable title. Equitable title here. Why there wouldn't be at least a fact issue on that issue?
Your Honor, there's no fact issue on that question because the facts are the deed. We are not, Texas law says we're not allowed to take another step unless those deeds are ambiguous. They are not. Texas law has also said that if the defendants don't allege that they're ambiguous, and they have never alleged they're ambiguous, the court is required to assume that they are unambiguous. And because of that reason alone, the facts that Ms. Compton wants to introduce are not a part of the analysis. Of course, she wants to do that to try to create a fact issue here, but it's just not allowed. The matter, both the defendant's summary judgment, Your Honor, and the plaintiffs agreed that the interpretation of the deeds is a question for the court as a matter of law. Both sides agreed on that. And that's because that's what the law says.
So let me ask this, and I don't necessarily disagree with that, but if I interpret that the deed, and that's kind of what I'm kind of formulating in my mind, that the deed says what the deed says, that doesn't mean that there couldn't also be an equitable trust, right? That would supersede that potentially.
That's what the law says, correct.
Your Honor, there would have to be some evidence. The case law, the Faust case that Ms. Compton just cited, stated that if the partnership, I believe it's the Faust case, that the partnership must be formed prior to the acquisition of the properties. Otherwise, it is impossible for one to contemplate that the partnership acquired.
Am I recalling the facts correctly that there was I don't remember what his role was, but there was somebody, an attorney for the partnership or something, who said that, I thought there was some facts about that.
Your Honor, there was a letter from Victor Richmond, and I can pull it up right now for the court because the this was what I was hoping to go through on the partnership issue. There is a memo that was a business record produced by the defendants in 1982, which is after all of the properties were acquired. The last property was acquired at the very beginning of the 1970s. And in this memo, Your Honor, the person who formed the partnership is saying that the plaintiffs are partners. But the point of the document being, at this point at least, that the date is after the acquisition. There is no evidence that exists, certainly no competent summary judgment evidence that exists to show that the partnership was formed prior to the acquisition, prior to even 1982. And the best evidence of that, Judge, is the fact that the assumed business name records filed in Dallas County prove it. The law says they must file assumed names with the county if in fact they're going to have a general partnership. And they've done that, and they've renewed that every 10 years. The first time it happened, as Ms. Compton, I think, referenced 1985, is when her client, Mark Richmond, took over. No assumed business records were filed prior to the acquisition of these properties. So the defendants simply claimed that the partnership was formed. It wasn't. It was not, and there's no evidence to say that it was. And so there needs to be a written transfer, a written document. Ms. Compton showed the court the case law. If the three siblings were going to transfer the partnership to the partnership, their interests in the properties, they could have done that. That could not have been oral. That would have had to have been in writing. That is the only way the partnership could now have title to the properties equitably. And there's just no other facts before the court to contest that, Your Honor, or to create a fact issue.
May I respond, Your Honor?
Briefly.
Absolutely briefly. Number one, the whole argument that you can only look at the four corners of the deed is not applicable to equitable title. And if the court will look at the Miller versus Gann case and the Jewell versus Jewell case, it says that you look at extrinsic evidence. It's an exception to the parole evidence when you're dealing with equitable title. And then also there is an abundance of evidence, Your Honor. It was not objected to. The declaration of Jerry Candy, who was Victor Richmond's personal accountant, and he was also the accountant for Richmond Trust back in the day, and he has personal knowledge, and this is Exhibit M if you want to look at it, Your Honor, and he had personal knowledge of the name of the bank account because he was dealing with it. He had all the records, and he said that Victor Richmond would gift money into the Richmond Trust partnership, and then he specifically had knowledge that the properties in dispute were bought out of the Richmond Trust bank account. And he said the Richmond Trust partnership was in existence and funded no later than April 26, 1966. And then two, he says Richmond Trust, in other words, all the properties were managed and leased by Richmond Trust. Expenses were paid out of there's only one bank account. Not one of the heirs have done anything. Neither Mark nor Harvey nor Judy did anything related to these properties. And then if you look at the court looks at, we provided, and the plaintiffs also have this as an exhibit, a tax return from Richmond Trust shows the date the business started as April 26, 1966, which was before the properties in dispute. I have it in the corner, and Yolanda could pull it up if you wanted to, Your Honor, that all of the tax returns say the property, the business Richmond Trust was started in the upper right-hand corner by April 26, 1966. And the law is clear, Your Honor. It is not correct what Mr. Tobolowski was saying is that, you can only look at the four corners of the deed. What you do is when there's equitable title, and if reading through the cases, Your Honor, the court then, once you determine that there's equitable title, then the court looks at all the intent of the partners to say, okay, who paid the taxes? Who paid the rent? Was it one bank account? Those are the things they look at. And to grant, and all doubt should be granted in favor of the non-movement in this case. So we would ask that you deny their summary judgment. Also, I mentioned to the court in our last hearing
But
that
Mr. Tobolowsky, on this point, what exactly are you moving for in summary judgment?
I'm moving for summary judgment on the plaintiffs have a declaratory judgment claim declaring the plaintiffs the owners of a 1/3 undivided interest in the properties in dispute, as well as in
That's not even what the deeds say, though, correct?
the deeds. The deeds transfer a undivided 1/3 interest in the properties to Judith Richmond, an undivided 1/3 interest to Harvey Richmond, and an undivided 1/3 interest to Mark Richmond, which, by the way, Judge, the term undivided is also extremely relevant, and it is why we don't go outside the deed, because that term itself means the right to an interest in a portion of the property, but the right to use all of the property. And
my point was that the deeds say there's like a 1/6 interest in a trust and another one. They're all three different. They're not 1/3, 1/3, 1/3.
They're not. There's only one of the three that are different, Your Honor. Two of the deeds deed 1/3 undivided interest specifically to Judith Richmond individually. And on top of that, it's the other grantees, the Mark Richmond trusts and the Harvey Richmond trusts that received 1/6 each. There are some comments that were just made by Ms. Compton that I have to respond to because they are not giving this court the complete story. But I want to be clear to not argue over facts that don't matter, Your Honor, because the law, not just the case law, but the TBOC provisions that Ms. Compton is relying on also prove that there's no fact dispute and that as a matter of law, the plaintiffs are rightful owners to their mother's.
Okay, Ms. Compton, did you plead? I assume you did, but I just want to make sure you pled equitable trust.
Yes, Your Honor.
As a defense to the declaratory judgment action.
We have a counterclaim and we have a declaratory judgment action that we have equitable title. And that's the same thing as an equitable trust. And then we also say in our fourth amended counterclaim that because of our equitable title, we are entitled to have the property conveyed. Like, in other words, when you find equitable title, the court has the right to say, you guys need to transfer title to Richmond Trust. And the other issue is under Longoria versus Lassiter, if the court determines there's superior equitable title, it prevails in a trespass to try title action. So I would just ask the court to I'm just saying, if you read through the cases on equitable title, what Mr. Tobolowsky is saying is not correct. All of those cases are saying they're trying to say the deed really said this, or I think it should be interpreted in this way. That's not what we're talking about. And that's not what all those cases said. All the cases about equitable title say separate and distinct. It's an exception to the parole evidence rule if there is equitable title argued about the property being in a partnership.
Your Honor, and this is briefed fully in the plaintiff's motion for summary judgment. Both of the defendants testified under oath at their depositions that their father, Victor Richmond, and their mother, Marion Richmond, purchased the properties. Both of them specifically admitted it was their parents' funds, which are not the partnership's funds. What you heard Ms. Compton argue is their new workaround, which is they're trying to.
So let me just say this. I think there's a fact issue here as to whether or not the partnership bought it or they bought it individually, all that kind of stuff. So I think there's a fact issue. So the issue then becomes, do I grant your summary judgment as to your declaratory judgment claim, but then leave their declaratory judgment claim that say that I'm just trying to think like as a jury charge, if I find as a matter of law that your declaratory, to the extent that your declaratory judgment claim accurately reflects what's in the lease and what's in the deed. Because I'm not sure it does, but if it does, I would find in your favor on that, but that wouldn't keep them from trying to assert at trial that there's an equitable title here, or would it just be better just not to rule on any of this?
Your Honor, it would be better for just a whole ball of wax to go to court and deny. That is my recommendation, because, because I think, if you rule in their favor on the idea that they're tenants in common, then, if they're determined to be tenants in common, then what you're saying is you're throwing out the equitable title argument altogether, in my opinion, and it's very important. And I think with all this briefing and reviewing all the evidence in favor of the non-movement, we would ask that you deny their summary judgment. Let us all put it in front of the jury and let them decide.
It's a very easy position for the defendant to take right now, Judge. I feel like I need to clarify the equitable title argument is simply that the properties were purchased by the partnership in the name
Mr.
of
Tobolowsky, I understand that. What I'm trying to figure out here, and I don't know that there's a right answer to this, is I know you don't agree with it, which is okay. Every hearing I have, at least one side doesn't agree, but I believe there's a fact issue on who purchased this property. Was it the partnership, or were they bought by the individuals, brothers and sisters? And so, assuming that is my ruling, can I still grant your summary judgment as to legal title and then let them assert at trial a defense to that as to equitable title, saying, look, the deed says this, the deed is not ambiguous. I think it's completely clear, each of the three different deeds. But there still may be a claim for equitable title. Is that making sense to you, Mr. Tobolowsky?
It is, Your Honor. I think that the appropriate course of action would be to deny the summary judgment if that's the case, because I think that until her summary judgment was filed, it was never contested that legal title was held the way it is held. Their summary judgment actually says legal titles in the name of the partnership, just to show the court the types of ways that they're changing what they claim to be the facts.
Anyway.
Can I say 1 second, Your Honor?
Ms. Compton, you've won this right now. If you want to keep going,
I don't want to go. Okay. Hands up, spirit finger.
All right. So I'm going to deny the summary judgment as to I guess, tenancy and comment, or your declaratory judgment. So to summarize what we've done today, I denied summary judgment on the fiduciary duty, denied summary judgment on the tenancy and comment on behalf of Mr. Tobolowsky's client, and then for the remaining claim, I granted the summary judgment for the whether or not there was a partnership, or whether or not, Mr. Tobolowsky's claims, whether or not Mr. Tobolowsky's clients are partners, and I found that they are not. Anything else I need to rule on today?
Yes, Your Honor. Plaintiff's motion to strike the expert of defendants, Roland Love, who is their expert, who's attempted to explain the law on the property dispute issue, which, mind you, is in disagreement with some of the things represented by the defense today. But that's
Ms. Compton, do you need this expert still after these rulings or not?
Your Honor, what I would say is, I'm trying to be brief. I don't know if that's in my personality, but what they're trying to say is he's only opining as to questions of law. And as you know, you can opine on mixed questions of fact and law. And the reason why I think it would be helpful to have Mr. Love, and I don't know if you know him, but he's like all this board certified and all in the area. But what I think he might be able to do for everybody's benefit is he can explain like how the partnership law, well, first of all, he can take the facts and opine as to the tenant in common issue. But also he talks about This is how the partnership law evolved. And I think that's so important for a jury to hear, because back in the day, you couldn't put property in the name of the partnership, even though you had a partnership, until the partnership law.
I mean, my inclination, if that's what you're saying, is that I would strike him because I don't think that's necessary or appropriate. But I'll be honest, I haven't read this particular motion. I've read the other stuff we ruled on previously, but I haven't read this.
Would you like to hold it, or?
I'd rather hold it, but unless you agree that that's all you're asserting, then I would probably strike him. But if
I
there's
prefer to hold it for now, if the court would like to do that.
Let's go ahead and hold it then. Anything else?
No, Your Honor.
So Tobolowski. Okay, give me an order on this by tomorrow. And anything else we need to chat about today?
Thank you, Your Honor.
Okay, just give me an order. Thank you. You guys have a good day.